Hello everyone, this video is meant to fulfill the final examination recruitment for the English Federal course. Before we jump into the legal analysis of one of the nation's most significant historical events, I would like to introduce myself. My name is Mia Sofia. I am from Class A with student ID is 121. I am a student of the Law Study Program, Faculty of Law, Jenderal Sudirman University. This video is presented for my course instructor, Miss Nisa Riasa, SPD MSL, and Mr. Mustafa Tabib Karyadi, SPD MPD. Today, I will be discussing the legal complexities surrounding the May 1998 riots. Okay, I will explain about the case background and legal issue. What becomes the background of the case is the extreme economic instability during the Asian financial crisis in 1997, which led to mass dissatisfaction with the new order regime. The case started when 4 students from Trisakti University were shot and killed on May 12, 1998. This event triggered a massive violent insurrection. From May 13 to May 15, 1998, Jakarta and several other cities were consumed by looting, arson, and horrific violence specifically targeting certain ethnic groups. The main legal issue here is whether these acts, which were whispered and appeared to be coordinated, constitute gross human rights violation under Indonesian and international law. Furthermore, we must address the issue of common responsibility whether military and police leaders at that time can be held legally accountable for failing to prevent the chaos. Okay, I will explain about relevant law. To understand this case from a legal perspective, we must look at the statutory framework. The applicable legal norm in this case is Law Number 26 of the year 2000 regarding human rights courts. According to Article 7, Article 8, and Article 9 of this law, gross violation of human rights include genocide and crimes against humanity. Crimes against humanity are defined as action committed as part of a wide purse or systematic attack direct against any civilian population. Under the provisions of the Criminal Code or KUHP, this action would usually be processed as ordinary crimes like murder or assault. However, because of the systematic nature of May 1998, the constitutional provisions and Law Number 26 of the year 2000 allow for the formation of an ad hoc human rights court to prosecute cases that occurred before the law was even enacted. Okay, I will explain about the evaluation of case handling. Now I will evaluate how the authorities have handled this case for more than 2 decades. Based on my analysis, the authorities failed to properly address the root of the problem. Although the National Commission on Human Rights or Komnas HAM declared in 2003 that there was evidence of crimes against humanity, the legal process has been stagnant. The Attorney General's office has repeatedly returned the investigation files. The court's decision, or in this case, the lack of a judicial trial, is questionable due to a lack of political will. The judgment of the state appears to be flawed because it ignores the right to truth. For the victims, I personally disagree with the way the state has resolved this through non-judicial resolution only. Legally speaking, a non-judicial path should not eliminate the criminal responsibility of the perpetrator. The authorities failed to consider that without a formal court ruling, the culture of impunity in Indonesia will never end. Okay, I will explain about the ethical and social implications. The ethical and social implications of this case are massive. This isn't just a cold case in a file cabinet. This decision to delay justice sets a rigorous standard for protecting citizens. When the state fails to provide a legal remedy for such a massive tragedy, it creates a legal trauma for the society. For justice to be fair, it must be accessible to everyone, including victims of the 1998 tragedy. Okay, I will explain about the conclusion. The conclude the May 1998 riots are a clear example of gross human rights violation that remain legally unpardonable until a proper court is held. Summarizing my stance, the Indonesian government must stop the cycle of impunity and immediately establish an ad hoc human rights court as mandated by our laws. That is all for my presentation. I hope this video provides a clear legal insight into the events of 1998. Thank you for your attention. Bye.